Good afternoon. Welcome to Grace and Gavel, where truth meets compassion. Today we are talking about the legal defense of silence and why the Fifth Amendment can convict. Silence is golden, they say, but in a courtroom, silence can echo like guilt. If the Fifth Amendment guarantees your right not to testify, why do juries feel like silence equals guilt? Today, we're going to dismantle one of the biggest misconceptions about American criminal trials and show you something most true crime shows never explain. If silence is a constitutional right, why does it still sound like guilt? Most people, jurors included, have this belief baked in from TV, movies, and news coverage. If someone pleads the Fifth, they must be hiding something. That's not just pop culture. Research is clear that lay people tend to view silence as suspicious, even when the Constitution says it doesn't matter. But the law and the psychology diverge dramatically. I will say that there are times in voir dire where I have actually had someone say, because I've asked about, do you assume that someone is guilty because they are silent? Or someone brings it up and says, I think that a defendant would not be silent if they didn't do it, which can taint a jury. And something like that, when you taint a jury, the whole jury has to go, because ultimately that person indicated something that is contraindicated for our system of justice. And it can poison the rest of the jury. Because people think that, just like running can be an indicia of guilt for some people, right? Why defendants do not testify. And I will say, that is the defendant has the last word, meaning they have the ultimate choice whether or not they're going to testify. Their attorney may say, looking at who they are and how long you've been representing them and how well you know them, you can say, I don't think it's a good idea that you testify. I'm like, oh no, I got this. I remember I had one gentleman in a jury trial for an OWI trial. And he said, oh, I have this, I've got this. And I knew, because I knew him, that he tended to be kind of cocky and, kind of a know-it-all about certain things. And one of the first things he did when he took the stand was he was talking to the prosecutor. And he said to the prosecutor, prosecutor said, well, you didn't take the field sobriety tests. And he's like, you're right, I didn't. And here's why. I read an article about a prosecutor similar to yourself, sir. And he said that the field sobriety tests are made to make us fail. And if a prosecutor like you wouldn't take it, why would I take it? I'm sitting there, I'm like, oh my goodness. And I'm like, he's like, and they're not even admissible in court. At which point I jumped to my feet. I'm like, objection, Your Honor. Improper legal opinion. And the judge is like, I'm going to let him go on. He appears to know what he's talking about. And I'm like, no, he doesn't. No, he does not. And then we're going a little bit further, and he starts talking about the fact that he probably shouldn't even be driving anyway, because there are multiple occasions where his partner at the time had thrown things at him, and he had like a really bad lazy eye. And so it affected his depth perception. So if she threw something at him, it would hit him, and he wouldn't really realize that it, he wouldn't even know that it was going to hit him before it hit him. And so I'm looking at him, I'm like, oh my gosh, why are you saying this? Why are you do not have this. You do not have this, and he's going into all these things, and I'm like, oh my goodness, this is just. So in a case like that, when a defendant doesn't know what they don't know and thinks that they've got it when they truly do not have it, versus in contrast, I had another defendant who was very good and skilled on his feet. He had literally had the jury eating out of his hand. I mean, they were laughing when he said certain things, and he just had them just reeled in, So ultimately it depends on the attorney's perception, but ultimately the client can say, I want to testify. And you can't say, no, you can't testify, because you're going to say something silly, or you're going to turn the jury against you, because you're going to sound like, you don't know what you're talking about, or you're going to give them more information than they need. And so that's ultimately sometimes why people don't testify. Or there's also the fear, cross-examination. I mean, the prosecution gets the opportunity to cross-examine your client. How strong is your client going to be? Does your client have a hair trigger temper? I mean, do you want them coming over the table at the prosecutor and threatening to kill him, or any number of things? Not saying that would happen, but or cussing them out, or any number of things that could not play well with the jury. So ultimately, I mean, your client has to have good control. Your client has to be relatively with it, and alert, not just kind of be lulled into questions, and have a good attention span. Because sometimes you think a question's going to go one way and it actually goes another way. Do you want the client to end up admitting that they did it? Kind of you can't handle the truth kind of statement. So, I mean, there's a lot of reasons why clients don't testify. Some of them know that they get nervous and they don't want to go about that. Some of them may feel like they're not going to play well. The attorney may feel like they might not play well. They have some weaknesses in their case at some point. And weaknesses do not automatically mean guilt, because ultimately the prosecutor and the defense attorneys are doing similar things. They're trying to make their case as strong as possible. And that's ultimately what it's about. So here's why defendants do not testify. And actually, Miranda rights started with someone named Miranda. And it was the right not to self-incriminate, and various other rights that you may know. And so the Fifth Amendment promises this: no person shall be compelled in any criminal case to be a witness against himself. That right protects defendants from being forced to testify against their own interests. Why lawyers often beg clients not to testify. No compulsion. Defendants can choose to testify, but they absolutely do not have to. So we're not to infer, and the jury is often given this instruction, just because a client doesn't testify, that doesn't mean that you can infer that they're guilty. Because why else would we have a constitutional amendment on that if you could infer that they were guilty? There would be no benefit to that whatsoever. There's an exposure risk. Testifying opens a defendant up to cross-examination, like I explained earlier, and can give prosecutors the opportunity to poke holes in their story. And some of the holes can be quite large. And then there's a credibility gamble. If a defendant's testimony is inconsistent, unconvincing, or emotional, it may do more harm than good. And that's the other thing. I know I've done a lot of videos on the optics. The optics are really important when it comes to criminal law. Very, very, very important. And from my personal experience, a lot of the clients that I've represented are extremely nervous. They are extremely fidgety and scared. So ultimately, they might be innocent, but their behavior could be misconstrued by the jury, which is probably the most unlikely thing, or the thing that you would likely want least of all. Because ultimately, even strong innocence isn't always better when told by the defendant, rather than framed by skilled defense counsel who can actually put together a strong argument and point out the key facts of the case that the jury can cling to and hold on to be able to use when they go into deliberations. Jury perception versus legal theory. Here's where psychology crashes into law. The legal rule: a jury is not supposed to infer guilt from a defendant's silence. This is Griffin v. California. The U.S. Supreme Court held The prosecutors cannot comment on a defendant's refusal to testify or invite the jury to treat silence as evidence of guilt. Furthermore, trial judges will often instruct jurors that they must not use silence against the defendant. But the psychological reality, human beings don't like gaps in stories, especially under suspicion. Studies and legal commentary suggest jurors, like lay people generally, naturally assume silence implies a lack of defense or a hidden truth, and they want to know that hidden truth. One defense attorney explains, even though jurors hear the instruction to disregard silence, human nature is to want to hear both sides of the story. So even with instructions, the absence of a narrative can feel like a vacuum filled with suspicion. Prosecutors' razor-thin line. Prosecutors are barred, meaning they are not able to do that. Doing that would likely result in a mistrial. From directly using trial silence against a defendant, but they still benefit from it subtly. How silence benefits prosecutors. A defendant who doesn't testify gives the prosecution a cleaner, unchallenged narrative regarding the evidence. Jurors may internally fill in the silence with what makes sense to them, often assuming guilt, even if instructed otherwise. Jury instructions help, but don't always fix interpretation. Because jurors are advised not to draw guilt inferences from silence, prosecutors walk a thin line. They can't comment on a defendant's choice to not testify, but they certainly aren't hurt by the void it creates in the defense's story. Complicating matters further. In pre-custodial questioning, silence before arrest, and before Miranda warnings, some courts have allowed the silence to be considered in limited ways, such as impeachment of credibility. An impeachment is when you actually have done a deposition or done a statement. Generally, it has to be sworn to. And so they will talk about your inconsistencies. So they will say, you said that you weren't at the intersection of such and such and such and such at 5 o'clock, but here you say you were actually here at 4. So were you not telling the truth when you said you were here at 5 rather than when you said you were here at 4? And it tries to subtly show that you're not being honest. That's what impeaching a witness is. The strategic gamble. Now, for the big tactical trade-off in every defense strategy. A silent defendant versus a volatile but compelling witness. Silence keeps the prosecution from cross-examining the defendant, which if you have a if you have a client who is volatile, who is prone to outbursts, then that is a huge gamble. Are they going to be able to keep it under control long enough, especially when they feel like the state is bringing them down? They feel like the prosecutor wants to get them for whatever reason. That's something that you would have to do an analysis of. Like, how volatile is this person? But does this person have things that this client have things that can actually add that maybe the jury would actually hold on to and realize that maybe this person is not guilty? It also protects against revealing damaging facts, because who's going to give those damaging facts, right? Potentially your client. Maybe your client wants to go into the fact that, oh yeah, I did a bunch of cocaine before I committed this crime. So, I don't really know what I did. I don't really know what I said. I don't know if I hurt. I don't know. Maybe I shot someone. I don't remember. Things like that would be like, oh my goodness. Like, we went in for this and now jury comes back with a verdict in 4 minutes, guilty. You're like, oh my goodness. That is terrible and devastating at the same time. However, silence leaves the defendant's voice out of the narrative picture, and jurors may subconsciously penalize that absence. And then also you talk about testifying. Testifying gives the jurors a face. Maybe they think that this person is friendly. Maybe they think that they're articulate. Maybe they like the voice and their explanation. And it can also humanize the defendant. It's so easy to continue saying the defendant. But when you actually have a face, you have a name, you have a voice, You go into the facts that humanize the defendant, such as how many children they might have, if they're married, things like that, what they do for a living, what kind of person they are, but opens up a direct attack by the prosecution. And if the testimony is weak, it can amplify perceived guilt. Defense attorneys often have to ask, is your voice worth the risk of a prosecutor dismantling it piece by piece? And different defendants have different strengths, different weaknesses. There has to be an analysis. There has to be a partnership between you and the defendant to know like what you actually are wanting to do. And that's why sometimes, even when a defendant wants to tell their story, lawyers counsel them not to take the stand because there's too much there to be able to allow the prosecution to mine their testimony and make it sound worse than what it is. Because, obviously they're going to twist words. They're not going to say word for word what the client said, right? They're going to twist the facts to make them sound probably likely worse than what they actually are. I don't know, coming from a defense counsel's perspective. What this teaches you, or what it should teach you as a layperson, we've all seen courtroom drama where silence seems to stamp guilt. Now you know. Legally, silence is a constitutional right, and prosecutors can't mention it for an adverse inference. Psychologically, silence still feels guilty to jurors and observers because they're not lawyers, right? Strategically, choosing whether to testify is one of the most pivotal decisions in a case. Additionally, I would also say voir dire, which is where you choose your jury, is also a huge pivotal decision. Ultimately, you make or break your case generally with the voir dire because you have to choose who to strike and who to choose, who you think would be on your client's side or receptive to your client. No true crime fan should ever watch another trial the same way again. So in closing, we hope today's episode gave you a deeper understanding of not just what the law is, but how human psychology interacts with it, and why silence, even when protected, can still speak louder than words in the jury's mind. Thank you for listening to Grace and Gavel, where truth meets compassion. Until next time, stay curious and keep questioning what really happens behind the courtroom doors. Thanks for tuning in, and I appreciate it. It means a lot to me that you all are enjoying our podcast. If you have topics that you're interested in, more legal topics or cases that you want us to dive into, feel free to drop them in the community. I do respond and I do interact in that community, so feel free. Thank you for tuning in. It means a lot to me. Thank you very much, and I hope you have a great rest of your day. Bye-bye.